In a landmark decision, the Supreme Court of India has delivered a crucial verdict, redefining justice and setting the course for the future. Through its verdict in the Bilkis Bano case on Monday, the apex court has set a landmark precedent on the issue of grant of remission to persons convicted of heinous crimes against women in India. The Supreme Court, in a scathing rebuke, cancelled the Gujarat government's order to release 11 convicts in the Bilkis Bano rape case, terming it a fraud act. This case, stemming from the 2002 post-Godhra riots, witnessed a horrific crime against Bilkis Bano and the killing of 7 of her family members. Bilkis Bano, just 21 years old and 5 months pregnant, was subjected to a brutal gang rape while fleeing the riots. Though the men who convicted this heinous crime were awarded life imprisonment in the case, in August 2022, the Gujarat government issued orders directing their premature release on account of good conduct. The Supreme Court, chaired by Justices B.V. Nagaratna and Ujjal Bhuyan, ruled that the Gujarat government was not competent to pass the release order, terming it a fraud act. The court emphasized that the appropriate government entitled to pass such orders was the Maharashtra government, since the trial took place in Maharashtra and not Gujarat. Bilkis Bano's petition challenging the early release of the convicts was deemed maintainable by the Supreme Court. While the court refused to delve into whether third parties can file petitions in criminal matters involving remission, the Supreme Court also nullified its own order from May 13, 2022, which had directed one of the convicts to approach the Gujarat government for premature release, stating that the order was obtained through fraud played on the court. The court held that the convicts had suppressed material facts and misled the court on multiple aspects while obtaining the May 2022 verdict. The court further condemned the Gujarat government for being complicit and acting in tandem with the convicts. The bench expressed strong disapproval of how the court's order was used to violate the rule of law by granting remission by the Gujarat government. The verdict mandates the convicts to surrender within 2 weeks and return to jail, marking a decisive turn in the pursuit of justice. Concluding the significant verdict, the Supreme Court held that it is the primary duty and the highest responsibility of this court to correct arbitrary orders at the earliest and maintain the confidence of the litigant public in the purity of the fountain of justice and thereby respect rule of law.
It's a very good judgment which has upheld the rule of law and the faith of the people of this country, particularly the women of this country, in rule of law, in the legal system, in the courts, and that there is an assurance of justice. In a very detailed judgment authored by Justice Nagaratna, it's a judgment of both the honorable judges, Justice Nagaratna and Justice Bhuyan. They have very categorically stated what is the legal analysis and reason for setting aside, quashing the remission orders and directing the convicts to return to prison within a fortnight. The court has said, and it's a scathing indictment of the state of Gujarat. The court has said that the law is clear. The appropriate government is the government where the accused are tried and sentenced, which, as we know, in the case of Bilkis Bano, which is a case emerging from the violence that took place in 2002 in Gujarat. And in this particular trial, there were about 14 counts of murder, including little babies and infants, and gang rapes of women, including a pregnant woman. And in this case, the trial was transferred by the Honorable Supreme Court to a special court in Maharashtra, where they were convicted, and that conviction has been upheld by all superior courts. Therefore, the appropriate government, as has been decided by this court and which is plain in the meaning of the Code of Criminal Procedure, Section 432, was the state of Maharashtra. The court said that the order that was obtained in 2022 May from this court saying that the state of Gujarat will decide is an order which was obtained by playing fraud upon this court. All facts were not placed before the court. If such an order is obtained, that order has no meaning in the eyes of law. It is a nullity in the eyes of law. And there are many judgments of the court which have been cited. Therefore, the court has said that given all this, the manner in which the remission orders were passed by the state of Gujarat, which had no power to do so, and the state of Gujarat should have actually gone in review and said, this order is wrong, it's contrary to the law, it's contrary to the judgments of the court. But they acted in a manner by granting, and they said a few things about, I'm yet to read the judgment, it has yet to be made available. They also said that the arbitrariness with which the discretion was exercised and the usurpation of power by the state of Gujarat, for all these and more reasons, rule of law must prevail. The court will uphold the rule of law, and therefore all the convicts have been directed to go back to prison within a fortnight.
Ma'am, which were the facts suppressed according to the Supreme Court?
Well, the fact that, they came here saying, state of Gujarat has told us we are not to, they can't do it. There was a petition first filed in the state of Gujarat. The High Court of Gujarat said, state of Maharashtra is the appropriate government. One application is filed there. Suppressing all that, they come to this court and say, well, we have been asked now to go to state of Maharashtra, which is the policy. So very interestingly, the policy also changes with each appropriate government between Gujarat and Maharashtra. And through all those facts, an order was obtained. And what the court is making clear, this is not just about the convicts. There is a state which is acting here, whether it is a state of Gujarat or any other state. What is the duty the state owes to people and to the court? If there is something that the court has passed where certain facts are not brought to its knowledge or certain facts are just suppressed, then is it not the duty of the state to bring that to the attention of the court? And therefore I say it is also a scathing indictment of the manner in which the state of Gujarat has conducted itself in this particular instance.
All 11 convicts in the Bilkis Bano rape case will return back to jail as the Supreme Court of India today reversed the Gujarat government's 2022 order directing their early release on remission. A bench of Justice B.V. Nagaratna and Justice Ujjal Bhayan clearly said that Gujarat government is not the appropriate government to decide on their early release. The court said that Supreme Court's May 2022 order, which had directed Gujarat to decide on the remission, was obtained by the convict by playing fraud and by misleading the court. Not just that, the court also pulled up the Gujarat government for being complicit and acting in tandem with that convict. A 21-year-old pregnant Bilkis Bano was gang raped in Gujarat. She had to see her family members, including her 3-year-old daughter, be brutally murdered. 20 years later, she had to see her perpetrators get out of jail and be garlanded. Now, she will finally see them walk back into jail as the Supreme Court has said that their remission was illegal. As the court today said, a woman deserves to be respected, whatever fate she may follow. With camera person Ridul, from New Delhi, this is Srishti Ojha, India Today.
Click on the link in the description to read more about the story. Don't forget to share the video and subscribe to Law Today for more updates about what is happening in courts across the country.